So, welcome to today's webinar, Stay Compliant or Pay Big, MiCA Requirements Crypto Exchanges Must Know. I am Sharon, Head of Communications and Partnerships at AMLBot, and I'll be your host for the session. MiCA is without a doubt a hot topic on the market. We received a lot of questions from you before the webinar and aim to cover them all. So, the goal of the session is for you to learn critical aspects of the new regulation and get clarity on key requirements for VASPs, specifically crypto exchanges. And today I'm joined by our legal expert, Niko, who will now introduce himself. Niko, happy to have you here.
Hi, thank you for the introduction, Sharon. Hi, everyone. My name is Niko Demchuk, and I'm a lawyer and the compliance specialist at AMLBot. So I have experience in law office, been house lawyer for crypto exchange, working in Big Four for AML audit. So I guess we'll have an interesting round today about MiCA.
Great. Thank you, Niko. Before we kick it off, some notes for the people in the audience. This is your chance to get practical advice from our expert. So please drop your questions in the Q&A below as we go. We'll make sure to cover them during the Q&A session towards the end of the webinar. Also, the recording will be shared with all the attendees after the session. So let's jump right in. Niko, the stage is yours.
Thank you so much. So then let's start. Today, I'm going to present you MiCA, but not just MiCA and what MiCA it is, because I'm sure all of you have heard about MiCA, you have some understanding what this regulation is about. So what I did is actually narrow down a bit the topic, and we will talk about MiCA requirements for crypto exchange businesses. Our agenda for today, so we'll first discuss who will be affected by MiCA, yes. Then we'll move to discuss what this transition period from those who are already operating in the market, having VASP registration, what would be the requirements they will need to comply with, what is the timeline, by what time they will need to be ready for MiCA, etc. Then we'll discuss application requirements for MiCA, meaning those who will be applying for MiCA, what are those requirements, or even if you are WASP, have a WASP registration, in most of the cases, you're still not fully compliant with MiCA. So what would be this new requirement that you would need to fulfill in order to get the MiCA license? Apart from MiCA, there will be some other requirements coming from different regulations. We will also touch upon that a bit. So what are those regulations that you will also need to comply if you would like to receive MiCA license? And then we will finish with the application review timeline, how much time it will take approximately for you to get a MiCA license if you're applying from the start. And a bonus also, I will give you some interesting statistics about WASP registration in different countries and my own subjective prediction how many of those WASPs that are already existing in the market in some countries, how many will be able to survive. So just stay till the end with us. So let's start with the introduction. As I previously said at the beginning, that this webinar is about MiCA requirements for crypto exchange businesses, meaning if you are providing of your plan to provide a crypto exchange to exchange crypto to crypto or exchange crypto to fiat, or if you would be operating a trading platform for crypto assets, then this webinar is for you because we will cover the requirement or some other related services. But for sure, what we'll not cover during this webinar is something that is related to stablecoins. If we are talking using the terminology of MiCA, it's e-money tokens or asset reference tokens. Because for them, there will be different requirements, meaning those who want to issue stablecoins in the European Union, then there will be different requirements. We will not touch upon that. So we will only focus on the part of crypto exchange services and around that. Why? Because first of all, not so many of those who actually would be issuing stablecoins. as I see in the market, there are many of those who have VASP registrations. They actually provide crypto to crypto exchange or trading, crypto trading, or custodial services, etc., but not issuing stable coins. So that's why my focus is on that, because it will affect most of the businesses in the European Union.
Also, guys, in the chat, we would love to know what sort of niche are you guys operating in the crypto sphere, in the crypto niche. So please drop the comments in the Q&A or your questions, and also in the chat. Let us know, what do you guys do, so we would be able to help you better.
Cool. So then let's continue about MiCA. Yes, so even though I know that you know about MiCA, but still some brief introduction to MiCA. So MiCA is a regulation, meaning that it will have a direct effect, that the regulation that you this doesn't matter where you will be situated, where you will be applying for the license. The rules, the requirements to receive MiCA license would be the same in every country of the European Economic Area. As of now, just to give you the comparison, crypto services regulated differently in different countries. So it's kind of crypto fragmentation regulation. If you go to Spain, it's a different regulation, a different set of rules you need to comply to receive WASP registration. If you go to Czech Republic or to Poland, it's totally different than if you go to Estonia. There are different regulations of crypto services. With MiCA, the regulation of crypto services would be same, and it doesn't matter which country you will pick as a country of your business setup. That's a big plus for crypto businesses, as now they would not need to wander and seek for VASP registration in every single European Union member state where they would love to provide a service. They receive one license in one country, and they can passport this license to another countries of the European Economic Area. So because the license is passportable. Now, if you receive VASP registration, let's say in Poland, it doesn't mean you can provide crypto services to Germany, to France, to Spain, to any other country in the European Union, because they have their own regulation. If you want to serve the residents of that country, you need to go there and receive VASP registration from Germany, from France, or from Spain. MiCA will solve this problem. You have one license, and you can passport this license, meaning just notify the financial supervisory authority of that country that you would like to offer your services in that country. You have been already licensed in MiCA in your home country, and the procedure would be very simple, just a notification. Also, MiCA provides better consumer and investor protection. Not like right now. Basically, if you have a VASP registration, you just need to comply with AML rules, that's it. But it doesn't really protect the rights of the users, of the consumers. With MiCA, this protection mechanism would be much higher. Who is affected by MiCA? Yes. Who are those who will need to get the MiCA license? No. First of all, of course, all the companies that are registered or set up in the European Economic Area, meaning European Union and Switzerland, Norway, Liechtenstein, and Iceland. So if you are registered there and you want to provide crypto services, you would need to apply for MiCA license. Also, if you are registered outside of the European Economic Area, but you want to serve EEA residents, meaning people who reside in the European Economic Area, you would also need to set up the business in European Union and apply for MiCA license. There is one exception to it, which is called, you would be able to still serve EEA resident without applying for MiCA license on a reverse solicitation basis. Indeed, MiCA offers such a possibility for businesses registered and licensed outside of the European Economic Area to still provide services to some of the residents in the European Economic Area if what does it mean, this reverse solicitation basis, if they come to this business on their own initiative, meaning there is no basically marketing, because crypto services, everything is done only online. So what does it mean on its own initiative? If they didn't see the advertisement in their own country and come to you, no, they somehow find out about your business if you are registered outside, and they come to you to receive some service. In this occasion, you would be able to provide a service. But if you will run some marketing campaign that will target some of the residents of the European Economic Area, even if you will have the website which would be in the language which is one of the languages of the European Economic Area, this might be triggered to apply for MiCA license, because this rule, reverse solicitation basis, is very unclear when it comes to marketing, what will be considered as a marketed as a targeting EA residents. Maybe if your website is in Spanish, yes, because there are Latin America that speak Spanish, but there's also Spain, and the resident and Spain has official Spanish language. So even maybe having the website in Spanish language would mean that you are targeting Spanish residents, and then you would need to apply for MiCA. Of course, there are other many details about what would be considered reverse solicitation basis or exception of it. For that, of course, I recommend you to go to lawyers and find their conclusion, to receive their conclusion, whether it's okay or not. And the third element, even though I said that we will not touch upon stable coins, but since I saw questions that I received from you before the webinar, and a bunch of those questions were about stable coins, I decided to include it also, just to briefly talk about it, so you will receive some of the answers. And I hope you will be satisfied. So I did not avoid your request. Some of you ask what would be stable coins. Yes, because MiCA also regulates issuers of stable coins such as e-money tokens or asset reference tokens. So the questions is clear, like is simple for those who are issuing stable coins. They would need to apply for MiCA license. There is a special set of rules. Or if you are already registered e-money institutions, or if you have a credit license, you would also have the right to issue stable coins in the European Union. That is clear, yes? But what to do if you are just a crypto exchange and you offer exchange Bitcoins to stable coins? That is something which is a gray area or unclear. And what I see, what is happening in the market, that many crypto exchanges, for example, Coinbase just recently published information that started from 2025, they will restrict access to some stable coins which are not authorized in the European Economic Area to the residents of the European Economic Area. What it means? That only those businesses that receive the license, MiCA license, or if they have e-money license or credit institutions license in the whole license in the European Economic Area would be able to issue stablecoins, and crypto exchanges that has MiCA license in the European Union would only work with those businesses who are authorized in the European Economic Area. For example, Circle, yes, maybe you have heard that Circle is the first, at least it was marketed like this, the first stablecoin issuer in the European Union that received MiCA license is authorized to issue stable coins. And now Circle is issued, they are authorized in France. They received e-money license, which also gives you the right to issue stable coins. And now they're issuing USDC and the Euro coin. Dollar coin and euro coin. So let's see what will be the second one, the third one, who will be the issuers. But what I see is that those crypto exchanges that offer exchanges from stable coins to crypto, to another crypto assets, they will most probably only allow exchange of stable coins of those who are licensed in the European Economic Area, and not others. So let's see what will happen to Tether. Let's see what will happen to DAI, etc. Maybe they will also will receive licensed in the European Union, or maybe the lawyers will think out of the box and will find the solution, some mechanism how they would still be able to serve EEA residents without having the MiCA license. Let's see, MiCA is new. It will come fully into force since 2025, and we will see how it will be in practice. We are talking right now only theoretically what will happen. So then let's talk about this transition, yes, from those who already have WASP registration to MiCA license. What I see in the market, yes. I will try to do my presentation as much practical as possible using my own experience. And what I see that would be a different level of preparation. For example, what I mean here, if you are WASP registered in Spain or in France or in Estonia, most probably this transition to MiCA license would be for you not as difficult as if you are a WASP registered in Czechia or Poland. That's for sure, because of the regulation in those countries. For example, Estonia has already developed a good regulation, which is the same level as strict as MiCA, with the same requirements almost. So, of course, if it's just some small things to do, it would be easier for the WASP already registered in Estonia to comply with some new requirements and get the MiCA license. But if you are a business that has received WASP registration in Poland or in Czech Republic, then it will be a lot of work for you. It's not a secret that it's very easy to get a WASP registration in Poland. It might be 1 month, 3 weeks. You just open the company, send the AML policy, which is very basic, usually template-based. No one really checks them. And in 1 week, you have your WASP registration and can provide crypto services. What would this mean? That, of course, MiCA has much more requirements that you will need to comply with, that we will talk soon. And for you to comply with MiCA, if you are WASP from Poland and from Czech Republic, and you didn't really develop so much good AML systems and processes and other requirements, would be a lot of work to do, a lot of resources to spend, such as money and human resources and efforts to spend, etc. Different level of supervision. It's also connected to the first one, because there are already businesses like WASP registered businesses that are already supervised by the Bank of, for example, in Lithuania, the Bank of Lithuania or the Bank of Spain, that are already, these authorities are already supervising e-money businesses, banks, etc. So they know how to review application, how to review the applicant, their requirements would be stricter. So they, of course, the businesses from there, they would be better prepared for MiCA license, because they would know that they are already very well reviewed, supervised, and there is no tricks anymore. But if you are, for example, from Poland, as Czechia, because I know this jurisdictions are very popular now, and I will tell you later why, and we will see how many WASP registered at the moment in those countries. No one really supervises you, even though you just in Czechia, you just open the company, you just notify the register that you will provide crypto asset services, and that's it. No one really checks your application, going deep what you're going to do and if your systems are effective, etc. Same in Poland. No one really checks you. You just provide basic stuff, do your business. No one comes to you. No one really reviews your application. No one comes to you asking questions. How is your KYC process is done? How do you mitigate this risk? How do you mitigate that risk? Also, very different. Yes, this is fragmented regulation in different countries. About the transitional period, yes, what MiCA says. MiCA says that there is 18 months since the date when MiCA fully comes into force. It gives 18 months for member states to allow registered WASP to comply with the new MiCA regulation. It means that by 1st of July 2026, yes, theoretically, they would still have some time, already registered WASP, to provide such a service. But MiCA also says that the country can narrow down this timeline. The next slide will show you some of the examples, what the countries have decided. But what I see in the market, that most of the countries will not offer 18 months transitional period, will offer much less. Usually it's 1 year. In most of the cases, it's only 6 months since MiCA comes fully into force. So if you're already registered WASP, or if you will receive your WASP before New Year, you will have at least 6 months, maybe 1 year, depends on the country where you registered, to comply with new MiCA requirements. If not, then you will need to cease to operate, and your WASP registration will be revoked. Also, important to remember that if you have WASP, even during this transitional period when MiCA is already in force, it doesn't give you the right to provide your services to another member state. It will be the same as now. You received your WASP in Poland, you can provide your WASP services, crypto exchange, custodial wallet, any other, only to Polish residents. It doesn't mean you can provide to Spain or to French residents, to German residents. No, if you want to provide there, you need to receive WASP there. So even when MiCA comes into force and you are not MiCA licensed yet, you are only in this transitional period, it doesn't give you the right to provide services to another member state. You still can provide services only in Poland. Unless you're fully MiCA licensed, then yes, you can passport your license and provide services to all the member states of the European Economic Area. Also, if you are a consumer of some WASP, you do not have, and you will not have the same MiCA protection also during this transitional period. Only when the business is fully MiCA licensed, then you can benefit from the rights that the MiCA gives to consumers and investors. And here you can see some transitional period that the country has decided. For example, Germany decided to have only 1 year transitional period. The Netherlands, Poland, Lithuania all decided to give only 6 months as transitional period to already registered WASP to be ready. If you're not ready by that time, then you will not have the right to provide crypto services anymore. You still need, by that time, you need to be fully MiCA licensed, or unfortunately, you will need to leave the country and find some other jurisdictions. Application requirements. So now we are talking in substance, yes, what you will need to do in order to receive a MiCA license. First of all, you will need to have a physical substance in the European Union, means that you will need to have an office and not a virtual office, as many countries now are doing, especially Poland and Czech Republic. No. You will need to have a real office where the people are working, where there is some effective management is going on, so there is some decision taken, and one of your director of the company needs to reside in the European, in one of the countries of the European Union. That are the physical substance requirements. Then, of course, you need to provide the information about your company, about services you are going to provide, describe them. It's clear. What is interesting, that in the application, you will need to include information how you're going to market your services, where you're going to market, and in which way you're going to market the services. This needs to be also added in the application. This needs to be reviewed. Why? Because crypto services is a financial services, and marketing of the financial services is strictly regulated, and it also regulated in this marketing domain. There are many countries in European Union, Spain, there is also UK, even it's not European Union, but there are many countries who have special requirements to companies who provide financial services, how you can how you can do marketing of your services. Same will apply to crypto asset service providers. You will need also to describe what is your governance arrangements, meaning your internal system, the company, who takes the decision, if you have directors, you have supervisory board, if you have any other senior management positions, what are the relations between them, who has the power to decide on what, etc. Directors of the crypto asset service providers and UBOs would need to go through the fit and proper test. What it means? It means that the supervisory authority who will be reviewing application would also need to be sure that the directors and the UBO of the company doesn't have any, for example, criminal past. So they will ask for the criminal records of any of the directors of UBOs. Also, if you are directors, you will need to prove that you have a special knowledge about crypto asset, about finance. You have skills to be a director of such a company. For UBOs, they will also check if you are of a good repute. There is no bad information about you in terms of money laundering, terrorist financing, any other financial fraud. Also here, we will not forget that there is a 12th package of European Union sanction against Russia, and the citizens of Russia and residents of Russia will not be able to be directors or UBOs of the crypto businesses in the European Union. So they will also check that. So basically, you will need to have a proper people in your management, and they will need to pass the test. Moving on to another requirement, and from my point of view, this is the most important requirement in the eyes of the financial regulators. You will need to prove that your internal policies and procedures are sound, effective, and mitigate all the risk depending on the services you are going to provide. What are those internal policies about? It's about anti-money laundering, basically, because this is the biggest threat in the eyes of the financial regulator, that your services, since you provide financial services, can be used to launder money, to help with tax evasion, to help do some financial fraud, etc. So they will need to be sure that the written policies you have, but not only, the systems you apply inside your company are effective, can mitigate all the risk, and the financial authorities that will be reviewing application would be sure that they can issue the license, and all the risk in terms of money laundering, in terms of terrorist financing, tax evasion, sanction evasion, etc., will be very well mitigated. Now, if you apply in most of the countries, you just send your AML policies, which might be only one document, most of the cases template, that the consulting companies who help you with the licenses give to every other same clients as you. You send it. Those who receive it check boxes. Okay, this is here, this is here, this is here. All done. License can be issued. No, this practice will stop. Really, every business will need to take it seriously, and the one policy which is 30, usually is 30 pages or 40 pages, will not be sufficient. You will need to show to the financial regulator how you do onboarding of the clients, how you rescore them, how you monitor their fiat transactions, their crypto transactions, how do you do reporting of the suspicious transactions, and it might be all separate policies and procedures. How do you store the data? How do you do trainings to your employees? It's also very important to train your employees. What is actually the system in your company? Who are those who will be doing KYC onboarding? Who will be those who will be supervising them? Some quality assurance. Who are those who will be doing transaction monitoring, investigation? If there is a suspicious transactions, then there needs to be done an investigation inside the company. If there is some reasonable ground to do FIU reporting to the law enforcement, or there is no ground and this case can be closed. This all will be checked in very detail, will be asked questions, and this is one of the most important point and most important requirements to show to the financial regulator, because their substantial threat and the risk when they issue the license that this business has a very well AML KYC sound system in place, and all the risk can be mitigated, and the business will not serve clients for sanctions, will not help companies to launder money, etc. Moving on to another requirement, of course, you will need to show also that since it's online business, everything is done online, that your ICT system is also very well developed. You have everything in place in terms of cybersecurity, in terms of protection against cyber attacks, etc. You will also need to provide a procedure to the financial regulator how you segregate the client's fund and the fund that belongs to the company itself. Yeah, so there is no anymore FTX case like it was in the past, and the client's funds are safe and they're not used for without the right of the clients for any other purposes. You also need to provide complaints handling procedure. So you will need to give rights to your users and your customers to complain about your services. It needs to be transparent. Those who are complaining needs to know what are the timing, when they will get the answer, what is the process, etc. If you operate a trading platform, so you will need also to provide to the financial regulators what are those operating rules. How do you actually detect market abuse? So there is no market making on your website, but in order to just to artificially raise the price of one tokens to another. And most of the cases also not only the procedures that is written, yes, you will also need to show that you also have some systems in place, so something that you are already using or you are planning to use. So not only documents that you will do that and that, no. Usually financial authority will also ask you, okay, you have this, but show me how you actually do it in practice or how you plan to do it in practice. Describe us to this. If you will provide custodial services, of course, you need to have also description of custody and administration policy. And if you provide crypto to crypto exchange or crypto to fiat exchange, you need to show to the authorities how you actually determine the price, what is your fees, etc. So there is a clear commercial policy for financial authority and also for your customers. What are those other requirements that if you are a crypto exchange, you would need to comply with? No, first of all, interesting, but white paper now becomes a key point. So if your user wants to do something with the crypto assets, you will need also to provide to this user access to this crypto asset white papers. Yes, white paper was very popular long ago when it was ICO. Everyone was issuing white paper describing the problems they are solving, the tokens they issue, what is the nature of the token, etc. So it again comes into place, but now it becomes a requirement, even if you are not the issuer of the crypto asset, but you just provide the operate a trading platform, or you provide the exchange, you also need to provide the white paper of every crypto assets you offer to your customers. The pricing policy, what is this exchange price, how it's created, what is your fee, what is the price of this exchange, etc., would be all need to be also very transparent, very clear, communicated to the customer before the exchange. Interesting also, the third requirement, yes, information related to principal adverse impacts on the climate. What it could be, yes, how is actually climate and sustainable development related to crypto exchange business. Here, it's also would be one of the requirements. You would need to have in your website, or maybe hyperlink to another website, information about each crypto asset and how much energy it consumes to mint these crypto assets or to mine these crypto assets, what is the effect on the environment, etc. So you would need to do this analysis. There is no template. So each crypto asset service provider, if you are operating a trading platform, you would need to find out how you want to describe all of this, get the data, and make this data available to your customers. White paper requirements. This is for those who wants to issue crypto assets, or who wants to who operates the trading platform, you will have some white paper requirements. For example, if you operate trading platform, you need to be sure that all the crypto assets you offer to your customers, they all have white papers. Plus, not only white papers you would need to have, but also you would need to get the kind of legal analysis of why this crypto asset is not e-money token, is not asset reference token, or is not a financial instrument, security, etc. Meaning why this crypto asset is a utility, yes, or payment token. Again, we come back to ICO period, 17, 18 years. Everyone was doing legal analysis on the token qualification. Everyone wanted to be a utility token because it means it's easy to do. Same here. So basically, MiCA mainly will regulate crypto assets who are utility tokens or who are payment tokens like Bitcoin, Ethereum, etc. But if it's a financial instrument, it's a different set of rules applies. It's MiFID, security laws. MiCA doesn't regulate this. It's a different license you will need to have in order to offer this. So you will need to have legal analysis of every crypto assets you have on your platform, and you need to notify it to the competent authority where you are licensed. And here's the question. Will you need, if you operate a trading platform, to go every time you want to list a new token on your platform, you need to go to lawyers, pay for legal opinion, receive their legal opinion if this token is not a security, is not e-money token, is not asset reference token, so you can offer it to the public or to trading. Still a question. The MiCA doesn't say it very clearly, but when I read it, being a lawyer, I understand it like this: additional costs for those who apply for MiCA license or who are already operating a trading platform on the MiCA license that you will need to keep in mind. Okay, let's move on with prudential requirements. So what are those share capital requirements that you will need to have in order to receive the MiCA license? This is depending on the services you're gonna provide, yes? Since we are mostly discussing crypto exchange services, so if you provide crypto to crypto exchange or crypto to fiat exchange, then your share capital requirement would be 125,000 euros. But if you provide a trading platform for crypto assets, that you will have the highest share capital requirement, which is 150,000 euros. So on this slide, we briefly discuss requirements that are coming from MiCA for crypto exchange businesses. But it's not all, yes? We briefly discussed them, so now I hope you have better understanding what you will need to do in order to comply with MiCA. But unfortunately, it's not all that MiCA applicant or MiCA license company would need to do or would need to take into consideration when applying to MiCA. There is other regulations that will have a direct effect on you. Which are those? First of all, those that are related to anti-money laundering and terrorist financing. So in European Union, now AML also we just have an AML directive. So it means like this case with the licensing, if you want to provide a service in Poland, you go there, you study the AML law in Poland in order to be sure that you comply with this law and you provide your services to Polish residents in compliance with the Polish AML law. Then if you want to provide a service to Germany market, then you need to go to Germany, study German AML laws to be sure you are not violating it, because in fact, usually, in essence, it's more or less the same, but there are still details every country has, how you need to do, for example, onboarding, what kind of information you are required to ask during the onboarding. It might be different in different countries. So you need to study every single country to be sure that you are actually in compliance with every single country AML regulation, not only crypto WASP registration like it is right now, but also AML regulation. It's additional cost as well. It's additional hurdles for the business. So starting from 2025, we will also have AML regulation, which is also a good step forward for businesses, because this AML requirements would be similar in every European Union member state. But it will also be AML directive, meaning that you will also need to take into consideration the local laws of the countries you're going to provide the business. So even if you are a MiCA license somewhere, you would still need to take into consideration the AML local laws. If they are really different from those that are coming from the AML regulation, you will need to comply in order to provide your service in a particular country with full compliance. Also, transfers of funds regulation, travel rule, very famous, the biggest headache of crypto business at the moment, to comply with travel rule, which will be applicable also from 2025. Here it's additional topic. Maybe we'll have additional seminar about it to talk what are the challenges right now, etc. But it's really a headache to comply with this travel rule. How you actually gonna share your data with receiving WASP or CASP, how you're gonna receive it, etc. DORA regulation, also applicable from 2025. What DORA means? That all your outsourcing services, you will need to analyze what are those that are critical, what are those that are not critical. If are those that are critical, you need to have some plan, what you're going to do if there is some problems, attacks happens, etc. And of course, GDPR. Also, you will need to think about GDPR when you provide your services. So apart from MiCA, a lot of requirements that we have, we also have other regulations that the MiCA licensed business will need to take into consideration when they're going to provide crypto asset services in the European Union. And the next slide is the statistics that I checked just around 1 week ago. Some countries and the existing licensed businesses as a WASP or CASP or virtual asset service provider. So let's see. Estonia, for example, has now 45 businesses that are licensed as a virtual asset service provider. I was living and working in Estonia for 5 years when it was very popular for crypto business. And I remember when Estonia had 2,000 licenses for crypto businesses. I think 3-4 years after that, now we see it's only 45. This is due to the changes of the law. Because now, if you remember, I said that Estonian requirements for crypto business are more or less the same as all the MiCA. There are only some details are missing. So that's why it's difficult to comply with, and all those 2,000 licenses disappeared because, of course, businesses were not ready for it. Lithuania, for example, at this moment has around 800 WASP licensed businesses. Poland has 1,500 licensed WASP businesses. And Czech Republic, Czechia has around 1,000 licensed businesses. It's a lot. And taking into consideration my Estonian experience and knowing how it's easy to get WASP registration in Poland, Lithuania, and Czechia, and that no one really checks them, etc., I am giving you my prediction, some inside information, what I think about how many of actually those existing WASP will survive when MiCA comes fully into force since 2025. So, I think, okay, Estonia has all the strict requirements, so I think when MiCA will come into force, they will not have this big effect and only a couple of companies will cease to disappear. But when it comes to Lithuania, Poland, or Czechia, I think around 18-90% will disappear, because I'm aware how it's easy to get a license. I'm aware that businesses who receive the license, not so much thinking about to implement the processes, etc. Most of them have virtual offices, do not have any a physical substance. Of course, many of them will try to comply with requirements, and that's why I think that around 200 in Lithuania and Poland will receive MiCA license. Out of those existing 1,000. In Czechia, I think it will be less because Poland is a big country. Lithuania is already very well known fintech center of the European Union. I think they are better prepared to serve this financial crypto businesses. Czechia is less popular. Now Czechia is only popular because it's the easiest way to receive VASP registration in European Union. No one really checks you. You just notify the registry, you provide the services, and that's basically it. So I think that when the MiCA comes into force, unfortunately, most of these companies will not be able to comply with MiCA requirements starting from new year. If they will have only 6 months, it's usually a lot of work to do. Maybe they will lose license, then maybe they will apply again when they are more ready. Maybe I'm wrong, I don't know, only time will show, but this is my experience based on my Estonian experience. Yes, Estonia has 2,000 license, 3 years later is only 45. So when Lithuania and Poland has also more than 1,000 license around that, I don't think a lot will survive when MiCA comes into force. So MiCA, don't be scared. Yes, I'm talking that there are a lot of requirements. MiCA has pluses. Yes, it's a homogeneous regulation, one license, passportable. But of course, for small businesses who doesn't have a lot of money, because to apply for MiCA, for example, also interesting information for you. I did the research and I asked for a price from the law firms in Czech Republic, how much it will cost to actually prepare your documentation for MiCA license. I received the answer that it would cost around 80,000 euros, and it will take around 1 or 2 years to prepare your company for the MiCA license. So timelines and money. And it's Czechia, yes. Of course, if you go to Germany, if you go to France, it might be up to 200,000 euros, 300,000 euros only to prepare all the documentation for MiCA licenses. Of course, it's a huge cost. Many of those VASP registered businesses in Poland and Czechia does not have this cost, does not have these revenues to cover the cost. So maybe they will look for another jurisdiction, or they will go to some sandbox that European Union offer. First try this, and if the idea is successful, then they will proceed with the MiCA license. And the last slide is about the timeline. Yes, so how much it will take for you to get the license. So here's the timeline. If everything is good, everything is perfect. Okay, of course, if you send the application, there is some questions, then the timeline might be extended. So according to the law of MiCA, what I calculated, it will take around 15 weeks, so 3.5 months, to get the license if your documents are perfect. Okay, because when you send the applications and within the 5 years, the supervisory authority, 5 working days, supervisory authority needs to notify that they received the application. Then they have 25 days to review your application and say the application is complete, or you still lack something, so you will need to send more documents or more information. After your application is complete, your supervisory authority in your country will have around 40 days to review your application and come up with a decision whether they grant you a MiCA license or refuse you in granting the MiCA license. And once the decision is taken, they will have 5 working days to notify you about their decision. So basically, again, if everything is perfect, around 4 months to get a license. Talking from experiences, being a regulatory lawyer who applies for licenses is almost never perfect. There's always questions coming from the supervisory authority. Always additional documents needs to be sent. Additional information needs to be prepared. So I think this timeline would be around 6 months. Also, of course, again, depends on the country, how well the supervisory authority ready, aware about crypto, aware about how it works, because it all matters. That's why I think that there will be some countries in the European Union who will be really popular for crypto other services, and everyone will be going there to receive the license and then provide your services to the whole European Union market. And this brings us to the end. So my conclusion, if you are a VASP registered company, first things you need to do, you need to take care of your AML KYC processes. This would be the key point financial supervisor authority will look at that you, first of all, has very well written AML policies procedures, and secondly, that in practice they are also very effective. So what is written, it's as well as good, effective, and very well executed in practice, in terms of AML, in terms of KYC, KYT, travel rule, etc. And now it's October, so MiCA starts, comes into force in January 2025, and then most of the countries has only 6 transitional period, not a lot of time left. So start acting now. And I'm done with my webinar, with my presentation.
Now, before we wrap up, let's open the floor for Q&A. If you have any questions, feel free to drop them in the Q&A box, and we already have some questions that we will cover now.
Okay, so then I'm opening Q&A and I'm reading the questions. The first question I see about travel rule. And will travel rule requirement prohibit individual clients from unhosted wallet usage? No, actually, this is very clear. Travel rule will not regulate if it's a transfer between unhosted wallet, meaning that if I have my own wallet and I send it to my friend's own wallet, there is no regulation. I can do it. I do not need to comply with any laws and any requirements. Different situation is when there is a CASP or WASP, and then there is a transfer, deposit, or withdrawal from my, for example, if I have an account in Coinbase, then I want to send it to my own wallet, then of course this would be regulated, and FATF travel rule regulates it, and the European Union as well. So the Coinbase will need to be sure that the wallet I'm sending does not have any risks. And this is where blockchain analytics come into play. So of course, even now, all the crypto businesses use blockchain analytics, meaning screen crypto transactions and crypto wallets on AML risks. So this would be one of the mitigation measure, of course, to screen the wallet first before allowing the user to do a deposit or withdrawal, and to see if this wallet has any kind of risk or not. So this is blockchain analytics that needs to be used. And then, of course, receive some other data about the wallet, to whom it belongs. It can be received from the customer, or it can be out of the box syncing, depending on the company, because the law doesn't really tell you how you need to get the data to whom the wallet belongs. So usually you ask questions from the customer who is interacting with the wallet. So again, blockchain analytics, KYT screening transaction will also play inevitable role when MiCA comes into place. Another question that we have from Elena: for the ICT audit required for the application penetration test on the ICT assets supporting critical and important functions as defined in Article of Regulation, then the following audit test approach is black box, gray box. If the company is gray box face and white box face will be obligatory as well. This is very specific questions, and I think it's coming from not maybe from mainly from DORA regulation. So I'm not aware about the details. I will need to check about these details. Very technical. So, question from Dmitry: will WASP licensed be eliminated in this case for each country? Yes, that's correct. So once MiCA comes into force, there will not be WASP registration anymore. It will be only MiCA licenses, and that's it. So if you will want to provide crypto services, you will need to receive MiCA license. WASP registration will disappear once the transitional period is over, depending on the country, 6 months, 1 year, 1.5 year, there will be no WASP registration. So a question from Kola: are there any list of authorized stablecoins? there is no such a list in the European Union. I think you need to get to check every country and to see if there is a licensed, authorized stablecoin issuer. As of now, I'm aware in European Union that it's only Circle that is authorized to issue USDC and the Euro coins. Let's see what will be in the future. I'm also, I think, if I'm not mistaken, I've heard that it will be maybe some also a unified registration portal where you can see who are those crypto as a service provider that are licensed in the European Union and by whom, by which country. There's a question, what is meant by passport your MiCA license? Could you clarify, please? Yes, sure. So what does it mean passportable MiCA license? It means, no, for example, now because now those who are licensed as e-money institution, they also passport their license, meaning there is e-money Revolut, yes, e-money institutions licensed in Lithuania. So they have e-money license in Lithuania, and they passport their license to another European Union member states, meaning they notify the financial supervisory authority of each member state they want to provide a service, that they say, hey, we are already licensed in Lithuania, this is our license, we want to provide the services to your country. This is the license, this is information about our company, this is information about the services we are going to provide. That's the only requirement they will need to do. The financial authority who receives this information, they just register them in their register that there is a cross-border service provider licensed in Lithuania will provide this kind of services in our country. So same happens with MiCA. Once you license in France, you want to provide your services to another member states, you pick member states you want to provide the services, you send notification to this member state financial authorities with explanation where you're licensed, what kind of services you're going to provide about the company, and that will be sufficient to be able to provide services there. Okay, let's move on. There is a question, which authorities authorized to issue MiCA license? So every country will have its own authority who will be issuing MiCA licenses. And most of the cases, it's usually it's a Bank of Lithuania, Bank of Spain. In some countries, it's also called Financial Supervisory Authority or Financial Inspection, etc. So it will be a dedicated body in each country who will be reviewing the application and issuing license. There is also an interesting question from Nazar. If I'm not an exchange or a trading platform, but simply want to accept payments in cryptocurrency, will I also need to obtain a license? First of all, this is not a legal advice. I'm not giving a legal recommendation. I think everyone who will provide any kind of crypto asset services or will deal with crypto assets will need to go to lawyers and get their legal opinion. But if you are just offering something online and one of your means of payment, you can have fiat, you can have card, you can have bank transfer, and you can also have this possibility, you give this possibility to your users to pay in cryptocurrencies like stable coins. I do not think this will fall under MiCA license. Okay, I guess it's already 1 hour, or we're already 1 minute. I think I'm done with Q&A.
Okay, okay. Thank you. Well, thank you all for attending today's webinar on MiCA compliance for crypto exchanges and bringing amazing questions. And thanks, Niko, for sharing knowledge and expertise with the audience. As Niko mentioned, AMLBot solutions help with a broad range of compliance-related requests. If you have more questions or want to learn more about how AMLBot can support your compliance efforts, reach out to us via the form provided. Link is in the chat. Have a great day.
Bye-bye.